Okay, we're live again. Great to have everybody. I'm kind of more I do these, the more I look forward to them because we just got a great group of people who participate and chat and who contribute. So we got another good one. This is let me tell you a quick story about kind of why I did this one. Um, Out there in internet world, whether it's on YouTube or you Google estate planning, living trust, getting your affairs in order, you see so much about here's all the benefits of a living trust. You know, you hear avoid probate, privacy, incapacity planning, saving taxes, avoiding estate conflicts, ongoing management of the assets after you pass away. There's a lot of truth to all that, but what I wanted to do this evening was really take a deeper dive into each one of those kind of proclaimed benefits and tell you really the backstory on all those benefits and quick background on me and my story. Of course, I'm an estate planning lawyer, well educated, after law school, master's degree in tax law from Washington University's law school. Um, and so have been working with people, ordinary people, probably just like you, for the last 30 something years, helping them get and keep their estate legal affairs in order. But how it kind of leads us to this topic that we have this evening is several years ago, I was approached by a national kind of online company that wanted to build a national document creation system for wills and trust and estate planning documents. So I took on that project, big project, and me and one of the employees who works for me, built that document drafting system for that would allow people all across America to enter information and build their estate planning documents. That company has since been acquired by another financial services firm. But nonetheless, as part of that project, we had to do a lot of research for all 50 states. And so we have just this incredible database of information on these estate planning areas that can vary a little bit from state to state. Things like executor fees when there's a probate, trustee fees when there's a trust, power of attorney rules that vary from state to state estate tax that a few states have and what those rules are. We had to research which states require certificates of trust when a trust is created, and when they do, what information needs to be in those certificates of trust. More on that later. Which states allow homes, vehicles, or even LLCs to be titled in a way to avoid probate by perhaps naming a beneficiary on a particular document as it relates to that particular type of asset. So we have incredible research. So that all that work that we did and all that research that we did, combined with the fact that I created this YouTube channel several years ago, and at some point after 2 or 3 years, it got really popular. Now more than, in fact, I just passed the 25 million views threshold. So thank you for being a part of that 25 million view journey that I've been on. So combination of doing a lot of work nationally and creating a YouTube channel that prompted people all over the country to, in some form, contact me and say, Paul, I'm in California, I'm in New York, I'm in New Jersey, I'm in Florida, I'm in Tennessee. Can you help me? So as a result of all that, years ago, I founded it's unique, but it's kind of a one of a kind national estate planning law firm. We have lawyers on staff that are licensed in many states for our clients who live in states where we don't have attorneys on staff. We have our co-counsel arrangements in those various states. So, for example, today I talked to a couple in New Jersey, and their goal was to just make things simple. They have the typical stuff: houses, brokerage accounts, and make things simple for the surviving spouse when one of them dies, and for their children after both of them die. To talk to another individual in Michigan, same situation, wanted to protect assets for the child after the parents pass away. So that's kind of my day-to-day activity. So the idea here is this live stream is by no means a knock or a bash or a criticism of the Revocable Living Trust. No way this is what this is. But in fact, I've created or I've been involved in the creation of thousands of trusts. But there are many claims being made about the benefits of a revocable living trust, and this is just merely a deeper dive into those benefits. So let's jump in. But by the way, if you've been on before, or even if you haven't been on before, here's the rules for our live stream. I want to present some information, probably for about 20 or 30 minutes, and then we're going to look over to the chat. And I try to go through that one by one while I'm on the live stream here. Keep it positive. Everybody does a great job with their questions and talking back and forth to each other in the chat. So feel free to contribute that. I've only had to block a couple of people after years of live streams who were a little snarky or a little negative, or a lot negative. But yeah, keep it positive. Comments, experiences, questions. Feel free to answer other people's questions or respond to their comments, and that helps everybody. So I love the fact that we have a little community out there. Okay, so now what we're going to do is we're going to look at these kind of proclaimed benefits of a revocable living trust, and then we're going to look at them pretty hard. So those are, avoid probate, keep your affairs private, make things easier when you become incapacitated, minimize disputes, avoid taxes, and provide for ongoing management of assets after you pass away. So the biggest one, and the one I'll hit first, is what most people think of, or maybe the first benefit that's discussed or addressed when people talk about the revocable living trust, and it is avoid probate. So for those of you who are rookies or beginners, in fact, the gentleman I spoke to today, he was like, I started this project 6 days ago, and I got focused. And he said, Paul, you wouldn't believe how many of your videos I watched. But in 6 days, he got himself really, really educated. And we had a really high level discussion about what he wants to do for his family. It was really amazing. So the idea, though, behind the whole living trust and avoid probate is, if there are things in your name when you pass away and you don't have a will, then I'm going to go through 3 scenarios. Things are in your name when you pass away, like your home, maybe a business, maybe a brokerage account, maybe a bank account, and you don't have a will. And those particular assets that I just mentioned, they don't have any kind of beneficiary designation attached to them. Well, when you die, your state has a plan for where those assets go, and there's what's called a probate required. All those assets are frozen when you die, and so your survivors, probably spouse and children if you're married and you have children if you have children and you're not married, those heirs that your state declares who are your heirs because you died without a will and you died with things in your name, they will all get together. They'll hire a lawyer. Typically, they'll go through a court and attorney involved probate process where judges get involved, and judges have to approve of things, and judges have to sign court orders ordering Fidelity, Vanguard, Schwab, the bank, to release the funds to the appropriate heirs. A lot of people get a little fed up with the probate process because it's kind of government controlled. You're going through our judicial system. Things tend to move slowly. So there's some quirks and there's some problems with our probate process. I wish we could clean it up, but it's a little bit archaic. Same process if you die with things in your name and you have a will. Some people mistakenly believe that if they have a will, the probate's avoided. That's not the case. If you die with a house and vehicles and stock in your name and a business, and you have a will that says, I leave everything to my 2 kids equally, your 2 kids will, when you pass away, the assets will be frozen. Your 2 kids will hire lawyers, go through the court and attorney involved probate process. It will likely take months, sometimes years, and attorneys, court fees, and all that, thousands of dollars. But they'll get it done eventually. But there's an aggravation and an expense and a time factor to all of that. So what some people do, this is where we get into the living trust to avoid probate, is what some people do. And sometimes I make reference to my old cartoon, Fred and Wilma Flintstone. Fred and Wilma Flintstone may say, we don't want our daughter Pebbles to go through that probate when we pass away. We don't want the survivor of us to go through probate when one of us passes away. So here's what we'll do. We'll set up a living trust. We understand that if we transfer our home from Fred and Wilma to Fred and Wilma as trustees of the Fred and Wilma Trust, and you do the same with your brokerage account and LLCs that you have, transfer ownership, or with LLCs, your membership interest is transferred from Fred and Wilma to Fred and Wilma as trustees of the Fred and Wilma Trust. things that are in the trust when you pass away, they don't get frozen, they don't get through probate. So depending upon how their trust is set up, if Fred dies, Wilma just keeps on doing what she's doing. When Wilma dies, perhaps the next day or within days after the surviving spouse dies, that trustee can transfer the assets out of the Fred and Wilma trust, perhaps into Pebble's name, all outside of lawyer and court involvement. So that's the idea behind the revocable living trust, and that's why the first benefit typically proclaimed when somebody talks about a revocable living trust is they avoid probate. And hey, when they work, it's a beautiful thing. Got a call last week, and some people who set up trust a little less informed than others, but got a call last week, and the gentleman said, I had set up a living trust for the gentleman and his wife several years ago, and the wife died, and I was having a conversation with the surviving husband, and he said, Paul, I'm calling you because I think I need to do my wife's probate. And I also I think I need to set up a trust to make sure that this house that I'm in goes to my wife's 2 daughters, because that's what she wanted. And so I, pulled up our records. I'm like, no, you don't need to do anything. It's already set up that way. So there was no probate required because all of the couple's assets that were at least the ones that needed to be were in the trust. She had an IRA and named her husband as the beneficiary. So that would automatically go to him outside of probate. So not only did they not need to do the wife's probate, but he also didn't need to take any action to make sure that the house was going to go to her 2 daughters, because that's what their trust already indicated. And we didn't have to change anything because they have that joint trust. Other times where I've seen it just work really, really well. Set up this week, I got a call from a son, or had a Zoom call with a son. And I had set up a trust for mom years ago. And I got a call from the son. Son says, Paul, my mother died 3 months ago. And I was like, well, sorry to hear that. I didn't even know about it. And the son said, but guess what? Everything's done. My mother had the trust that you set up. And so the son said, I'm the successor trustee. I already dealt with all the brokerage firms and already transferred the house to the beneficiary who was designated in mom's trust. And so everything's been taken care of. And the reason I'm calling you, Paul, is because now when I saw what happened and how it was so easy when mom passed away, me and my wife want to do the same thing so that our kids can have a similar experience. So when it works, everything works great, and all the probates avoided. There are circumstances, though, when even though with the best intentions, somebody's setting up a living trust, sometimes probate is necessary. Let me go through some of those circumstances where a probate is or may be necessary when somebody died, even though they had a living trust. So when we talk about when a probate is required, even though somebody had a living trust, typically the first topic that comes up is, wow, the trust was not funded, or the trust was not fully funded. So what that means is when Fred and Wilma set up their trust, getting their estate affairs in order is not finished when Fred and Wilma each sign their trust, putting it into effect. In order to avoid probate, Fred and Wilma's probate assets, that I'll call them, non-probate assets, are things like IRAs and life insurance where you have beneficiaries. Those avoid probate by their nature. But Fred and Wilma also own some probate assets, houses, LLCs, brokerage accounts, stock. And so the key to avoiding probate is not just having the trust, it's transferring those probate assets to the trust while Fred and Wilma are alive. And so that nothing is in their name to be frozen to go through probate when they die. So sometimes either a trust is not what I'll call fully funded. All of the assets that needed to get in the trust did not get in the trust. One of the things that we do through our law firm to minimize the chances that would happen is we create an online vault account for each of our clients, and we ask our clients to populate the various categories of assets in that vault: real estate, retirement accounts, brokerage accounts, bank accounts, vehicles, business interests. So they populate everything that they own in their online vault account that they'll have forever and that their survivors can access to make sure every bit of estate information is in one place. Really handy. But so that allows us, when they populate their online vault with all of their assets, it allows us to ensure that the assets that need to get transferred into the trust get transferred. But sometimes, they clients will forget that they owned assets, and so they either didn't let us know, didn't put in their own online vault that they had a few shares in a computer share account that they completely forgot about, or they owned 1/4 of their parents' family property. They own it with their 3 other siblings, and they just kind of forgot that they owned that. Or maybe there's some brokerage account out there that they never use and they forgot about that. Or had one recently where a gentleman owned shares of stock in a country club, and so he forgot to bring that up and didn't tell us about it, and it didn't get transferred to his trust. And when he died, that share or those shares of stock in the country club were still in his name, and we had to do the probate, use his pour over will, as we say, to go through the probate, get the will determined valid or probated, where a judge declares the will is valid, and get the judge to sign the appropriate court orders ordering the country club to transfer that gentleman's shares of stock from his name into his trust, so that the trustee of the trust could do what they needed to do with the country club stock. So, you just see sometimes the trust does not get fully funded and a probate is required. Sometimes a probate is required even though the trust is fully funded and all the assets that need to be in there are in there. But after somebody dies, somebody wants to write a check payable to the estate. Maybe it's a insurance check on some homeowner's claim. Maybe it's a tax refund from the IRS or from the state. And they know that the taxpayer died, so they write the check to estate of Fred Flintstone. Well, Fred's dead, and even if there still exists an account in the name of Fred Flintstone, you can't deposit a check written to estate of Fred Flintstone into Fred Flintstone's checking account. You need to have an estate account to deposit any checks payable to an estate into. So in order to get an estate account, you have to open a probate, get a judge involved, get a judge to confirm the executor or appoint an administrator if there's no will. And then that gives that representative of the estate the court orders that they need to take to a bank and open an estate account. A person who's just named in a will can't go to a bank after the person who made the will dies and open an estate account. The bank will not let them. The bank wants to see the court order confirming that that representative has been confirmed as the representative of the estate, often called an executor or personal representative or administrator. So sometimes a probate's required because a check pops up after someone dies payable to that person's estate, and you've got to open a probate to be able to have someone open an estate account. Sometimes there's a refund check from the nursing home or the assisted living facility, and they make the check payable to estate of Fred Flintstone. You need an estate account. Sometimes there's life insurance money that gets payable to the estate. Maybe Fred years ago bought a life insurance policy, and he named Wilma as his primary beneficiary, and he just neglected to name contingent beneficiaries. He did this a long time ago. And Wilma died before Fred, and now Fred died. Well, Wilma's named as the beneficiary, but she's dead. It doesn't go to her estate. You look to the contingent beneficiaries, and there aren't any. So perhaps the life insurance contract says if there's no named beneficiaries, then the life insurance company is going to make that check payable to the estate of the insured. And so again, you have to open the probate. So my point is, when it works to avoid probate, it is a beautiful thing, but by no means is making a statement of, if you create a living trust, there is guaranteed to be no probate when you die. There's no guarantees there. But when it works great. And typically people do their best to try to make sure that the assets that need to be in the trust are in the trust. But because life is uncertain and people and things happen, and in business and in finance and in law, sometimes the probate is necessary. So, all right. I will also say that the whole you have to have a living trust to avoid probate, that statement is getting less and less true over the years because more states are creating legislation and enabling you to title things and register things in a way so that the probate is avoided, even if you don't have a living trust. So, for a very, very long time, as long as I've been around, there have been IRAs and life insurance, and those are always payable to designated beneficiaries. And along the way, states created legislation allowing people to designate on their bank accounts who they'd want their bank account payable on death, POD, after they die, so they can register an account that way. And that's another way to avoid probate. Brokerage accounts in many states, and most states, almost all states, you can register that transfer on death to someone. And now we have some states that enable you to title your home with a transfer on death deed, or some states their motor vehicle office has created. The state has created legislation allowing motor vehicle offices to designate you and allowed you to register your vehicle in a way where you own it, but transferred on death to a particular beneficiary. Some people even do that. Some states even do that with LLCs. So I'm finding that the trend across our country and the trend across state legislatures is to continue creating legislation to enable people to set up things so that it can be passed along to one or more beneficiaries outside of probate without having to have a living trust. Living trusts are still very common, and there's a lot of other reasons to have living trusts, which we'll get into, as opposed to relying on TOD or POD beneficiary designations. But just making you aware that there are other vehicles in place that also allow certain assets to be left behind outside of putting them in a living trust. Okay, so there's our probate thing. And as I'm looking at Maria has a beneficiary deed for your home. There you go. Missouri's one of those states. Okay, and I'll get back to that later. I just peeked at the chat for a second and saw Maria, so I had to see what she was saying. All right, next benefit I want to talk about when people talk about living trusts that you get if you have a living trust is the privacy benefit. So there's a lot of truth to it, and then we've got to dive deeper. So yes, trust instruments do not get filed into the public record. But, so if Fred and Wilma Flintstone create the Fred and Wilma Flintstone Revocable Living Trust, that trust in all of its terms are not going to be registered anywhere, recorded with the state, recorded at a courthouse. However, if a trust owns real estate, there is some public information about that trust that needs to go into the public records, because when the trustees need to sell trust real estate, this publicly recorded certificate of trust or extract of trust tells third parties and title examiners who has the authority to sell property that's in the trust. So I want to go over, and so that really dampers the whole privacy thing, where you would think that not even that you would think, but it's often proclaimed that if you have a trust, everything about it is private. But if your trust owns real estate, this is where some of our national research really came in handy, because states differ in what they require to be filed in the land records where that property is located. But while it does vary, most, if a trust owns real estate, a certificate of trust or an extract of trust that gets recorded in the public land records typically must provide the name of the trust. And as a result of that, some people name their trust the XYZ Trust, or whatever, that's a trust that's not in their name. But the trust certificate, which gets filed in the public records, also must state the date of the trust, the settlor's name, who set up the trust. So that gets put into the public record. The sometimes the settlors who set up the trust, their address has to be put in the trust certificate. Not much, but in fact, if they're also the trustee, which they typically are, their address will be put in that trustee address part that's on the certificate as well. So the current trustee is on that certificate of trust, the current trustee address, whether the trust is revocable, and if it is revocable, by who. And then a few states also require who's the successor trustee of the trust. When the initial trustee dies, who's going to be the trustee? Some states require that. Some states even require who are the beneficiaries of the trust to receive the trust assets when the settlors die. Again, not common, but some states provide that. And then also some states require when does the trust terminate, and what's the trust termination information. And then there's some other information that's not really privacy related, but it's typically needs to be included in these trust certificates, like what rights does the trustee have to sell, to mortgage, if there are multiple trustees, can those trustees act independently or by majority or unanimous? So all this tells title examiners who has the authority to transact trust real estate. Sometimes also there's some homestead exemption language that must be in the trust. So there's some while during your lifetime, of course, if you leave everything in your name and you have a will that provides where your stuff goes when you die, there's no will certificate that needs to be recorded in the parish records with all of that information that's in a trust certificate. But if you have a will and leaving things, your survivors are going to have to go through that probate process as well. So, but I will say on the privacy thing, if someone says, you know what, I don't need to do a trust. I hear you that there may be some privacy component with a living trust, but I'm going to do a will. So what information becomes in the public record when somebody has a will and they die? Well, the will gets recorded in the probate record, and it's typically in the public record. Occasionally, judges will seal that record, but that's not common. And then there's also an inventory of all of the assets, all their bank accounts, their brokerage accounts, the values. And in some states, that can be requested that it be sealed from public view. So sometimes there's a privacy component to that if that record is sealed. So the probate proceeding is designed to be a very public proceeding, although along the lines of people getting frustrated with that, some states have enacted legislation enabling some aspects of the probate proceeding to remain private through the court pleadings or the inventory of assets, or in some cases, even the will being sealed outside of public view. Okay, so there's some murky waters when it comes to the privacy aspect. Yeah, and I know that there are people out there and promoting, okay, well, create your living trust, name it something different, have an LLC that's the trustee of your trust, have the beneficiaries of your trust be other trusts. Gets complicated, lots of layers of complexity in order to try to keep things invisible. I'm not a big fan of overloading people with all that administration, but know that there's some of that out there. As I stay in this privacy section, I also want to kind of go over that there's some areas where not so much private, but people can be a little bit sneaky. So I've seen some situations where John and Jane, they have 3 children, but maybe one of their children is favored. And so they'll create the John and Jane Trust, and that, John and Jane Trust will own their home and will own certain accounts and may even own their business. And the John and Jane Trust says when John and Jane die, then, maybe one of the kids is the trustee and the trust assets are to be dispersed to all 3 children equally. Boy, that sounds great. Sounds fair. Every child is is being treated exactly the same financially. But then John and Jane have this favored child. So they don't want all of their children to know this, but they set up the John and Jane Revocable Living Trust number two and named, and maybe the John and Jane Revocable Living Trust number two owns a brokerage account with $1 million in it. And the John and Jane Revocable Living Trust number two says that favored child, when John and Jane die, is the trustee, and favored child after John and Jane die is the sole beneficiary of trust number two. And the sneaky part about it is because that trust only contains a financial account, no real estate, nothing in the public records, then John and Jane just may be getting away with it of thinking of all of the children, or at least the other two who didn't get the bonus, thinking, oh, my mom and dad treated all of us equally. But then the favored child, when mom and dad die, they go to Schwab or Fidelity or E-Trade or Vanguard or wherever that John and Jane Trust number two account is held, and they can settle that account outside of anything that has to do with any of the other siblings. So seen that a few times. That goes under the privacy category. I've also seen, I'll call this under the privacy category, where John and Jane says, Paul, we got two kids and they don't get along at all. I don't want them even to have to deal with each other at all when we pass away. So John and Jane Doe set up John and Jane Trust number one and name one child as the trustee and beneficiary of that when John and Jane pass away. And then they create John and Jane Trust number two and designate the other child as the trustee and beneficiary of John and Jane Trust number two. And that way, when John and Jane die, child number one can go deal with trust number one as the only trustee and beneficiary and get those assets. And child two can go deal with trust number two and by him or herself deal with all of those assets. So that kind of strategy falls under this privacy setting, but we don't see that kind of much. Okay, so that's the privacy issue. Living trust can be very private, especially when they don't own real estate. And I've seen some people set up trusts just for the real estate, and then another trust which has all of that privacy, and they want all of those terms to be private and trustees and beneficiaries, and they create a separate trust for all those assets that can remain private. So lots of issues there. And if it's privacy, you're after, everybody's circumstance is unique, so we have to look at it. All right, next benefit that you read in your bullet point of benefits to a revocable living trust is what I'll call incapacity planning. Fred and Wilma have their living trust. Maybe Fred died. Now Wilma's the sole trustee. She goes crazy. She loses capacity. So is it going to be chaos? Or is it going to be simplified because Fred and Wilma have the Fred and Wilma Living Trust? Okay, so here's the deal. What will happen is Fred died. Wilma is the sole trustee of the Fred and Wilma Trust or the Wilma Trust. And her mind goes. If she gets Alzheimer's, she gets injured, whatever. She does not have the capacity to deal with her money. So Wilma is likely to have some trust assets, things like a home, a business, maybe some brokerage accounts, maybe some bank accounts. And then Wilma's also likely to have some non-probate assets, things like IRAs, Roth IRAs, maybe some annuities that remain in Wilma's name because those have beneficiaries. So Fred and Wilma set everything up. They set their living trust up so that Pebbles is the successor trustee. And most living trusts say something like, if the surviving spouse is either dies or is incapacitated, then the successor trustee steps in. And many trusts, have to define what incapacitated means. Maybe it requires a doctor's statement. Or maybe the beneficiaries can declare that a settlor is incapacitated. Not real hard to prove that somebody died, and Pebbles can step in as the successor trustee when Fred and Wilma die because Pebbles is going to get some death certificates. But so now, when Fred died and Wilma's incapacitated, Pebbles can step in, and should be pretty easy for her to step into that successor trustee role and start taking over and managing the trust assets on Wilma's behalf for the rest of Wilma's lifetime. But as the successor trustee, she's not going to be able to transact Wilma's IRA or her annuity that's not in the trust. So Pebbles would likely use the power of attorney that Wilma created. When Fred and Wilma set this up, Wilma created a durable power of attorney in addition to creating the trust. That durable power of attorney that Wilma signs says, if I'm incapacitated, if I'm not able to sign my name and deal with my accounts, I want Fred to do it. And if Fred's not around, I want Pebbles to do it. And maybe after Fred died, Wilma updated her power of attorney and moved, Pebbles to the top of the line. So when Wilma becomes incapacitated, Pebbles is going to have to fill that role of, boy, I got to manage all of my mom's stuff for the rest of her lifetime. And Pebbles will manage it either as the successor trustee of the Fred and Wilma Trust for trust assets and as the agent on Wilma's durable power of attorney for assets that are still in Wilma's name. So you don't have to have that revocable living trust to enable a trusted loved one to be able to transact your stuff in the event that you become incapacitated. If you just keep everything in your name, then again, the idea is that you sign that durable power of attorney, and whoever you designated can then transact all of those assets that are in your name. I will say a lot of arguments out there, many of them have merit, that it's easier for a successor trustee to transact trust assets than it is for an agent named on a durable power of attorney to transact assets that are in the principal's name. Because a lot of financial institutions, a lot of third parties, they get real reluctant to honor powers of attorney. They don't want to release the funds for fear that the financial institutions will be liable for releasing the money to the wrong people. So sometimes they won't honor powers of attorney. It doesn't have their excuses. It doesn't have the right language. It's too old. There's a whole list of things that a financial institution might say when they don't want to honor a power of attorney. Now, legislatures in many states are creating legislation, really forcing third parties to honor a power of attorney, or at least explain within so many business days why they will either accept or reject a power of attorney. And many state legislatures are creating penalties that can be assessed to third parties when they inappropriately rejected a power of attorney. So my point there is, yes, does a living trust aid in incapacity planning? Yes, particularly if you have successor trustees named and the trust language makes it fairly easy for that successor trustee to transact trust business in the event of the settlor's incapacity. But even if you don't have a living trust and you do have that durable power of attorney, that's the other alternative for incapacity planning. Okay, so that's incapacity planning. The next is this proclaimed benefit that having a revocable living trust minimizes the possibility for disputes. Not necessarily so on this one. So as I go over this topic, does a living trust minimize the chance that the trust or the estate will be disputed? To really analyze that, we have to look at why estates or trusts get disputed or contested. And let's look at these reasons and see if having a living trust somehow minimizes the possibility that there could be a conflict. So one reason stuff gets contested is when someone dies and some survivor argues, hey, whatever they sign, their will or their trust, it's invalid because when they signed it, they did not have the capacity to understand what they were doing. That argument can be made whether somebody signs a will or a trust or a power of attorney. So, creating a trust doesn't necessarily eliminate the fact that someone may argue that that trust is invalid due to their lack of capacity. Another reason this stuff gets contested is what I'll call undue influence. Hey, you know what? My sister took care of my mom every day, and I know she snuck my mom out of the house. My sister arranged a meeting with the lawyer. My sister was in all of the conversations. My sister told the lawyer what to write, and the lawyer wrote a will, and my mother signed it, and my mother left everything to my sister. And so now that my mother's died, I think I want to declare that will invalid because my sister exerted too much undue influence over my mother when my mother wrote her will. Well, that argument can be made whether mom wrote a will or whether mom wrote a trust. So I really don't see where having a trust makes, can minimize a dispute if that's the issue. Another reason people contest estate planning documents is due to the fact that perhaps validity requirements were not met. You know what? The rule on a will is that it be notarized and witnessed by two people. Or the rule on a trust is that it must be, signed on such and such page, maybe notarized, maybe witnessed by people. And whatever those validity requirements were for a will or for a trust, they weren't met. So that will is invalid or that trust is invalid. So again, it's another one of those things where a trust could be declared invalid for failing to comply with the validity requirements, just as easy as a will could be declared invalid for failing to comply with the validity requirements. And a fourth reason estate documents get contested is that the language in the document can be interpreted different ways. It's not real clear what that provision means. It could be interpreted two different ways. Could be the case for a will, could be the case for a trust. So if that's the argument, having a living trust doesn't really minimize disputes, more so than something else. And then virtually all states have these no contest clauses, or I say all states. In most states, if they recognize no contest clauses, the old if this person contests something, they get nothing clause. I think in every state, if it's allowed for wills, it's allowed for trusts. If it's not allowed for wills, it's not allowed for trusts. So again, kind of no more minimizing dispute protection by creating a trust than creating will. Bottom line on all this is take care of this stuff when your mind is good. Make sure that you work with the right advisors who can ensure that the validity requirements are met, that the language used, particularly in the bequest portions of your will or trust, is clear, can't be subject to different interpretations. Make sure that that when you do this, not only does it not appear that you were unduly influenced, but make sure that you weren't unduly influenced. So bottom line is, doing all these things right can minimize disputes, whether you create your will or whether you create your trust. Okay, so next issue is taxes. So, when you see the bullet point benefits of a revocable living trust, typically one of the bullet points you see is, hey, get a living trust, helps you avoid taxes. Let's take a deeper dive into that. Okay. First, we'll talk, a lot of different kinds of tax. First, we'll talk about the federal estate tax, even though it doesn't apply to many people. So the quickie version of that, for people who die in 2024, the first $13.61 million that they have is exempt from the 40% federal estate tax. The tax applies on only the assets that they have that exceed the $13.61 million amount. Oh, by the way, it'll be adjusted for inflation in 2025, probably around $14 million. be adjusted again in 2026, but it'll be cut in half back to 7 or 7.5 million. So whether assets are in your name when you die and you have beneficiaries attached, your IRA, your life insurance, TOD beneficiary, POD beneficiary, whether those assets are in your name and they are transferred to others through a probate process when you die with a will, or whether those assets are in your revocable living trust to avoid probate to be easily transferred to your beneficiaries when you die. Under all those circumstances, all of those assets are in your estate for federal estate tax purposes. So, this revocable living trust, people often, dig deep with me. They're like, Paul, am I going to pay more or less tax if I create one of these revocable living trusts? And generally speaking, it is a tax neutral decision. You're not going to pay any more tax and you're not going to pay any less tax, because assets that are in your revocable living trust, they're treated as being owned by you. So if they produce some income, you just report that on your personal return, just like you would if the assets were in your name. So no difference on the estate tax. Assets in your revocable living trust, just like assets in your name, appreciated assets, they get that step up in basis when you pass away. So you don't have to have a revocable living trust to get that. I'm going to get a little complicated here, but some people with large estates will set up what's called a Q-tip trust. I've done some presentations on that. So even if the estate tax exemption is $7 million, but they have $10 million when they die, they can leave that excess $3 million to a Q-tip trust if they're married, and they leave it for the benefit of their spouse. And their estate gets a deduction for what was left in the Q-tip trust for the benefit of the spouse, assuming an estate tax return is filed and a Q-tip election is made. High level stuff, blah, 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 you're probably hearing. But, and so many people set up living trusts so that no estate tax has to be paid when the first spouse dies, because things are left in a way to qualify for this marital deduction. Well, you can do that with your living trust. You could also do it with your will if you leave your assets in your name. And again, I'm repeating myself here, but if you do it through your will, then your survivors are going to have to go through the court and attorney involved probate process when you pass away to get the assets transferred. So a lot of people like creating that revocable living trust, because then assets can be transferred at death outside of the court and attorney involved process. But you don't have to have the living trust in order to accomplish this estate tax deferral. It can be done through a will as well. All right. And then what happens tax-wise? Let's say there's no estate tax due. Mom died this year. She had $10 million. She can have $13.61 million, no estate tax. Cross that off the list. Okay, so here's perhaps an advantage of having a revocable living trust. It's an income tax thing. So living trusts tend to get settled quicker than estates that go through probate get settled. And let's say, make it easy, Mom died on January 1, 2024. And at that point, Mom's trust becomes irrevocable. And now the trust will have to pay income tax on any trust income that gets the trust will have to pay income tax on income that the trust generates from the time that Mom dies until the time that the assets are distributed to the trust beneficiaries. Same thing with the estate. If Mom has a will, leaves all of her assets to her kids through her estate. Mom dies on January 1, 2024. The estate will have to pay income tax on the income that the estate generates from the date that Mom dies until the estate assets go through the probate and are ultimately dispersed to the heirs. Now, the income tax rates for trusts and estates, they're the same. But just to give an example, a married couple filing jointly pays tax at the highest 37% rate when they have over $701,000 of income in 2024. Trusts and estates pay income tax at the highest 37% rate when they have more than $15,200 of income. So the rates are the same, but the brackets are really compressed for trusts and estates. Since generally trusts get settled estates, since trusts that get settled outside of all the court and lawyer involvement, trusts tend to get settled, meaning estates are transferred from the trust to the beneficiaries at a quicker pace than estates get settled. I'm just pulling numbers out of thin air. Let's say it takes 3 months for a trust to get settled. Let's say it takes a year and a half for an estate to go through probate and get settled. Well, that estate is going to be accruing a lot of income, and that income during that year 2024 would likely have been taxed to the extent it was over 37%. I mean, over 15,200 at 37%. Where if those trust assets are dispersed quickly to the beneficiaries, now those assets, once they belong to the beneficiaries, start producing income, and then that income gets taxed at the beneficiaries' personal income tax rate. So there is an advantage worth mentioning from an income tax standpoint, just because trusts get settled quicker typically than estates do. Okay, so that's the taxes piece. The ongoing management piece. A lot of in the bullet list of here's the benefits of a revocable living trust. There can be ongoing management of the assets after you pass away. All that is true. Fred and Wilma may set up the Fred and Wilma Revocable Living Trust. Pebbles is 17 years old. And so Fred and Wilma say, boy, if we both pass away, we want all of our assets to be for Pebbles, but Pebbles is 17. So we don't want her hands getting all of that money in one lump sum. So the Fred and Wilma Trust says that when Fred and Wilma die, assets will go into a trust for Pebbles, and that trust will last for a period of years. And then all of the distribution terms and dates at which Pebbles could control the assets, perhaps put them in her name, all that would be declared in the Fred and Wilma Trust instrument. So what that's called, or at least what I call it, and what most people call it, is Fred and Wilma. In the Fred and Wilma Trust, they created a subtrust for Pebbles. And maybe the terms of that subtrust are right there in the Fred and Wilma Trust. Or maybe there's a separate standalone subtrust called the Pebbles Trust. And in the Fred and Wilma Trust, it says when Fred and Wilma die, assets will be transferred from the Fred and Wilma Trust to the separate standalone Pebbles Trust. It can be done either way. My point is, they could have done that. A revocable living trust isn't the only way to do it. It's a great way to do it because all those assets get transferred after Fred and Wilma die outside of all the court and attorney involved probate proceeding. But Fred and Wilma could have set up a will with a testamentary trust. So when people provide for ongoing management of the assets after they die, they typically, and they want to keep their assets in their name for some reason and do it through a will, Fred and Wilma will each create wills, and those wills somehow will say after we both die, assets will go in trust for Pebbles, and here's all the terms of that trust, and all of that is in the four corners of Fred's will and Wilma's will. It's called a testamentary trust. So when someone has a will and they leave assets to a trust, it's called a testamentary trust. But again, when Fred and Wilma die, there's still that probate required to get the judges involved and lawyers involved to see that the assets are transferred to the Pebbles Trust. But when it's done through Fred and Wilma's Revocable Living Trust, that trust for Pebbles is called a subtrust. And again, all that gets transferred after Fred and Wilma die outside of probate. So that's it's typically simpler done through Fred and Wilma's Living Trust. But my point is, it's not the only vehicle for somebody to be able to do that. Okay, so I hope what you're gathering here is, before I go to the chat, this Revocable Living Trust, it's a tool that really most Americans kind of can and should use to simplify this moving of assets either to a spouse or to the children or to the next generation or to the grandchildren. Great tool. It's one of many estate planning tools that people have. And what people can and should like most about that living trust is that it simplifies the management and the transfer of trust assets outside of the court and lawyer involved probate, typically much more efficient than having a will and relying on the government probate process to oversee the settling of the estate. But when we start looking at some of the other benefits of privacy and incapacity planning and minimizing disputes and avoiding taxes, when we look at those other kind of proclaimed benefits of the Revocable Living Trust, just know that there are alternatives that can accomplish those objectives. So not knocking the revocable living trust by any stretch, but like I said earlier, just wanted to take a deeper dive into the proclaimed benefits of the revocable living trust, just so everybody can have as much knowledge as they can. As we go to the chat, I've mentioned it here. My goal is just if I can help one more American, and not necessarily me personally help them, but if information that people get can cause them to go get some things in order. My grandparents did that for me, had an impact on my life, and I want to see more people do it for themselves, their spouses, their children, their grandchildren as well. So that's all while we're here. Well, why we're here. Okay, so let me go over to the chat, and chat's always a challenge because I never know what I'm going to see, and I sometimes read it right here live. But so far, it's been good. Of course, Larry, Susie, everybody, all our fantastic community people here. Some weather talk. Aaron, hey, thanks Soto, Alex, for the states that have uniform probate process and not different things equal. Do you recommend So, great question, Alex. Do I recommend a revocable living trust or a testamentary trust? What I recommend is that people make an informed decision. So, as long as we can put that information out there, I'm not going to say one way is better than the other. I want to say, okay, you have this as an option. You have this as an option. Here's some pros and cons of this. Here's some pros and cons of this. What are you thinking? And so I never really tell people what to do. I always like to enable them to make those informed decisions. But if I were to give you a little inkling, Alex, sometimes the decisions that people make are based on their prior life experiences. So I'll hear a lot of, boy, mom died 2 years ago. The probate still isn't finished. I want to do a revocable living trust. Or I'll hear, Dad died 7 years ago, and I don't remember the probate being difficult. So I'm good doing a will just like Dad is. Now, maybe their circumstances could be different than their parents, but I will say many people rely on their prior life experiences when making these decisions. So there's no one perfect solution that just applies to everyone. And so again, I've done many will plans that included testamentary trusts, and I've done many trust plans. So that's my vague answer that I can give you. I want people to make informed decisions. And good to see you, even though you're late. Larry and yep. Placing vehicle in an RL. My state doesn't do TOD titles, forcing probate if not in, or some say vehicle. Okay, so yeah. And this is one of those where all the state research really helped, because states are pretty quickly creating ways for people to transfer their vehicles outside of probate by doing various things, signing certain motor vehicle forms or what have you. But you live in a state where you can't do that. So no, it's I've never seen an adverse thing happen to someone because they transferred their vehicle to their trust. I would suggest letting your automobile insurer know and have the trust named as an additional insured. That's a real good idea. But I've never seen somebody kind of have an adverse consequence because they transferred their vehicle to their trust. When everything was taken care of, one less thing. Good. So when your mother passed away, good. Ann, hey, SW, vehicle, okay, good. Hi, good. Shane, hi. A lot of highs, a lot of highs, and a lot of hand emojis. I always like those emojis. Missouri has a beneficiary deed for your home. We talked about that earlier. Based on your experience, what percentage of states with the trust still go through probate because some assets were not retitled to the trust? Good question, Alex. Whew, I'd have to just make a WAG, wild blank guess. Oh gosh, I hate to guess because I'm going to be wrong. But if I had a percentage, maybe 25% would go through. A probate would be necessary for one of the reasons that I explained. Trust wasn't funded. The estate received a check to the estate. Assets that people forgot about. Life insurance policy payable to the estate. So sometimes it's it's nobody's fault, but it happens. So, but when there is that probate, that probate is generally and typically simpler than the probate that would have to take place if all of the assets were in the deceased person's name. I will also say that when someone has a trust and there still needs to be a probate because something wasn't in the trust, that probate typically involves only one person, the executor of the will and the successor trustee of the revocable living trust, which almost every time is the same person. So that one person goes through probate. It's an easier probate because you don't have 5 or 6 or 7 personalities involved in the probate, where one of them might not be willing to sign something that needs to be signed to get things in motion. And so that one person probate gets the asset transferred from the estate to the living trust, and then that successor trustee can deal with everything outside of probate. But good question and just a wild guess. Maybe it's not even 25%. So is it better to hold investment as an LLC? Well, most people, I would say, they do own their investment real estate in an LLC. And that way, if there's some liability, somebody injures themselves on the property, they're going to sue the owner, and the owner is the LLC, as opposed to if that investment property is in your name, they would sue you, and more personal assets are subject to seizure. So most people, they do own it in an LLC, but if the LLC is in your name, if you're the sole member individually, then that LLC will have to go through probate when you die. So you transfer your LLC to your trust. So property in the LLC, LLC in the trust is what a lot of people do. What about land trust? A land trust is something similar to a revocable living trust. Only a handful of states have technically called land trusts. I live in Washington. An executor has a trust, and an executor has a trust open in my kid's name, but the judge has closed the estate or finalized it. Does that executor have to give up the funds at that? Sometimes I don't know if this is what you're getting at, agenda. Sometimes the probate will be finished. I don't know what you're getting at, but what it prompted, I don't understand your question. I'd have to study it a little more, and I'm kind of in a hurry. Sometimes you'll have a probate and finish it, and all these assets get transferred, and then somebody comes up, oh, I didn't realize they had this piece of property, or I didn't realize they had this account, and the probate's finished. So you got to reopen the probate, get a judge to sign an order ordering that additional asset be transferred to the appropriate heirs. And an executor has a trust open in my kid's name, but the judge has closed the estate or final. I don't really. And if judge has closed and they haven't given up the trust who are minors, can I reopen the case? I just not getting enough of the circumstances to be able to comment intelligently. I always hear that about power of attorney, and I guess you're talking about sometimes they refuse to honor it. States are getting better at forcing third parties to honor it, but it is an issue. So that has to do with the incapacity planning. Successor trustees of trust generally don't have that problem. My relationship, when she signed her affidavit of executiveship and signed the oath, can I find her for breach of the oath from the beginning? Maybe. A lot going on there, agenda. So that's a unique set of circumstances that I probably shouldn't or couldn't even address on this. Okay, Susie, good. Paul, on an irrevocable trust, is any income that is distributed to the beneficiaries taxed to the beneficiaries? That's the general rule, Shane. Income, if an irrevocable trust that is not a grantor trust, you may want to check my video on that we did yesterday. It's posted on YouTube. But if an irrevocable trust that is a non-grantor trust has income and it distributes that income in the same year to the beneficiary, then the beneficiary pays income tax at their individual income tax rate. If there was some income that was not distributed and was accumulated in the trust, then yes, the trust will pay income tax on that accumulated income. Good question, Shane. All right, second judge swimming. So now we got 2 judges. Expert witness. Yeah, that screams litigation, and litigation is not my field. For bank accounts, should the trust be the beneficiary? Good question. So I have done a number of times where a couple will set up a trust that provides for ongoing management of the assets for the beneficiaries after the trust settlors die. And so what the settlors will do is sometimes they'll keep their brokerage accounts in their name and then designate the trust as the TOD beneficiary in order to trigger the ongoing management of the assets after the settlors pass away, instead of just naming individuals as beneficiaries where it would get thrown into their laps in one big lump sum. So trusts can be TOD and POD beneficiaries. All right. Thank you, Whiskey Business. That's my goal, and thank you for mentioning that. Makes me feel good. Dan Butler, multiple properties, can a place individual trust each property, and can you and your company? Brittany's out. Thank you for your class. Demonstrate. Yeah, I'm gonna pass through agendas. They're long ones, and you're involved in some litigation, it sounds like. So if anybody else wants to comment on that, feel free. Johnny Five, would it be odd for someone to get a second attorney to review a trust before you finalize it with your primary lawyer to make sure otherwise errors or omissions? Maybe that sounds a little bit like getting a second opinion from a doctor, which the good doctors even recommend that people get a second opinion. Pros and cons to that, Johnny Five. Pros are maybe the second opinion lawyer will catch something that the first lawyer didn't catch or didn't provide for. The cons are maybe having a second lawyer review what the first lawyer did could just make you more confused than you already were, because typically the second lawyer is probably going to want to show their expertise by pointing things out that the first lawyer did wrong. I'm not saying that's the case in every case, but lawyers are really awful and sometimes overly critical when reviewing another attorney's work when they don't know that other attorney and they're getting paid for the review. They kind of feel like they need to justify their expenses. Hate to say it's kind of a knock on the legal profession, but I'm just telling you issues that might pop up. But if you feel like that's necessary and would make you feel better and have more peace of mind, then I think you should do it. Mike, if the grantor does his job, the RT process drives out the answers to questions normally asked after death, while the best person to answer them, the grantor is alive and fully aware. Yep. So I think what you're getting out there is part of being a good benefactor, person who creates a will or a living trust, person who wants to make things easy, provide for their loved ones, is not only just creation of a bunch of legal instruments, but also communicating kind of the desire and what's behind all of that, the whys. I don't know if that's what you're getting at, Michael, but in the areas where things go smooth, Ann Landers once said it, if you ever want to really get to know somebody, share an inheritance with them. So where I've seen things go really well is where the parents get the children involved on the front end, especially if there's that potential for conflict. Parents say, hey guys, here's what I did. Here's why I did it. And here's what I would expect of you when the time comes. Sometimes that communication helps. Sometimes it's done in person. Sometimes it's done in writing outside of the legal documents. Boy, we got some good stuff here. Let's see. I think I scrolled too quickly. Have you done a segment regarding irrevocable trusts? I touch on irrevocable trusts all the time. I don't remember. I have to go back and check. You can check on my channel. Let's see. And check out his list. Yeah, and great minds think alike. Ann and I are thinking the same. Many questions. Maybe I should contact your firm directly. Maybe not. Depends on your circumstances. I mean, our firm does the way we work is we take people who have no plan in place or their plan is so old, and we help them design a plan, create a plan, implement it. Maybe feel free to and the way to get it started is to go into the what's it called? Not the comments, but the description of the video. You'll see a link where you can request a Zoom meeting, and that's how it all starts. You answer a few questions, and then if it's appropriate, we'll send you my calendar link, and then we're off and running. You're welcome, Chelsea. Good, Larry. Good. I appreciate your comments. It's an excellent discussion. You've been on the good, you've been on the not so good. So I am worked. I do work hard. So but I do enjoy what I do. I like my time off, but quite frankly, at the point that I'm in my life right now, got 5 kids, got a great wife. She's in the room next door. 3 of my kids are already corporate lawyers. 2 of my kids are in law school, empty nest. If I'm not doing this, I'm probably laying down on the sofa, scrolling away, and I don't want to do that. So happy to be here, and I'm glad you're here. Glad all of you are here. All right. And so yes, that Raider girl. No, we don't have. There's we absorb the cost of that initial conversation to see if it makes sense for what you're trying to accomplish and what we can help you accomplish to see if that's a good fit. So feel free to check the link in the description of the YouTube video, and away we go. Good. A lot of stuff going on here. Good. A lot of you agreeing with others. All right. So thank you, Larry, for responding to agenda. That, yeah, it seems like you got a lot of questions there, and it seemed like it involves litigation. So you'll need to talk to somebody who can guide you through that. Sunkissed Earth. I was thinking the same when we had ours created, and how. Okay. Good. A lot of just comments here. Okay. Is there a minimum wealth threshold where it makes sense to establish a revocable living trust? 2 million, 6 million, etc. So yeah, I've been asked that question a lot, and the long blabber, maybe 1.5 minute answer is it's similar to, well, it's not similar to the wealth managers who do the financial planning and the retirement income planning, who it's not a perfect science, but it's like, well, once you get to this number, you can retire. And it's not exactly like that, but certainly the bigger your investment number is, the more likely it is that you can retire. Estate planning and living trust, it's not necessarily a how much question. It's more of a what do you have, because some people have 3 properties that are worth $50,000 a piece, and some people have 3 properties that are worth $1.5 million a piece, and perhaps they want their survivors to avoid the probate process on getting those 3 properties transferred to their survivors when they die. So it's more of a what do you have? How many assets would you have? How can they be arranged? What's the simplest way to make sure you accomplish your goal of making it easy for your spouse or your survivors, or setting up trust for your children if that's necessary? And let's just figure out what's the best path. Now, I will say someone with a $30,000 estate, or even maybe $100,000 estate, because typically the expense of setting up a trust is typically a little more than setting up a will. That person with the $100,000 estate, they're fighting to save every penny that they have because they don't want to run out of money. And so some people, they're like, well, maybe I don't want to get a living trust because I'm trying to save every penny that I can. Yes, if my survivors have to go through probate because I either have a will or I don't have a will, but I leave everything in my name, that's okay. So really small estates tend to not set up a living trust, but it's not a how much do you have to have. It's let's look at what you have and what's the easiest way to accomplish what you're trying to accomplish. So kind of a vague answer, but it's my answer. Oh my goodness, and it goes on. Let's see, and I'm scrolling, and yeah, probably put a pause on agendas. I'm not even looking at it. Attorneys who I have contacted, dumbfounded by my grandfather's will, and he was in full. Okay, yeah. All right, Sheila, greetings and thank you very much, Paul. You're welcome, Sheila. You don't know, guys. You don't know how much that makes me feel good when you say those nice things. So, really appreciate all of you being on the live stream here. Y'all have a great day. We'll see you next time. Don't have any plan right now, but I'll get on it and we'll plan some for the near future. Y'all have a great day.